All rise. The District Court of San Andreas is now in session. The Honorable Judge Castillo presiding. Honorable Judge Mann co-presiding.
Okay. Thank you. Please be seated. The court is now in session. We have the State of San Andreas versus Luca LaPorte. Case number 17760. Who do we have representing the state? Please state your first and last name.
Kennedy Cartwright.
Thank you, Ms. Cartwright. And then who do we, sorry, let's see here. Prosecution, are your witnesses present?
I believe so.
Thank you. Who do we have representing the defendant today?
Your Honor, for the defense is Oliver Hall.
All right, Mr. Hall. Let's see here.
And Cyrus Hunt as well.
Okay, thank you. Is your defendant present?
Yes.
Perfect. Prosecution and defense, do we have any pre-trial motions?
We do not.
From the defense, Your Honor.
All right, perfect. Prosecution, please read the list of charges.
Charges are attempted or unarmed robbery and felony evading law enforcement via a vehicle.
All right, defense, how does the defendant plead to these charges?
Your Honor, the defendant pleads not guilty to all counts.
All right, we'll enter his plea into court. Prosecution, you have the will. Please proceed with your opening statement.
Okay. These chairs are going to be the death of me, but Your Honor, in this case, the defendant is being charged with attempted robbery and felony evading of law enforcement. The evidence will show that this defendant is not only guilty of felony evading, but also attempted robbery. You will see throughout the testimony given that the defendant was present at the store, triggered the store's alarm for robbery, and then began to flee the scene. Upon arrival of the officers, the defendant was found fleeing, and the defendant did not stop. The defendant became exceedingly more dangerous in his attempts to evade and escape. The evidence will show that there were no other possible suspects in or around the store, exiting the store, or fleeing the store other than the defendant. The defendant was detained in the same vehicle found fleeing the scene of the robbery and was then found to have a hacking device on his person. You'll find that there are no other options than to find the defendant guilty of the charges being pressed. Thank you.
All right, defense, you have the will. Please proceed with your opening statement.
Okay.
Your Honor, the defense does not have an opening statement.
I'm sorry, could you repeat that, please?
Of course, Your Honor, the defense does not have an opening statement.
All right. Okay, prosecution, please call your first witness.
I will be calling Officer 504, Aiden Walker, I believe. If he is present.
Mr. Walker, are you present?
Maybe, maybe not. Is there a Walker back here?
Mr. Walker's not present now.
Okay, then he's not present. So is Hugo, I don't know how to say his last name, present?
Stiglitz.
Hugo Stiglitz is not present.
Okay, then we'll go with Mr. Ward. Oh, lovely. Okay.
From my understanding, Mr. Stiglitz did indicate that they would be attending. We'll address that matter afterwards.
All right. Hey, Trooper, do you want to go ahead and raise both hands for me? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, if you would, go ahead and stand right there next to the judge.
Are you able to hear me, or do you want me to step closer?
I can hear you.
Okay.
Your Honor,
Officer,
may we approach the bench?
It's up to him.
Approach.
What side do you guys want? That side? This side? declined. There are other witnesses that can still show that this was your your client was still guilty.
Ok. Bon,
There are also
c'est
written
même.
statements which do stand as evidence.
Your Honor, defense, of course, would submit that as far as the deposition, that we should be correct, as defense wasn't offered at any point participate in that deposition.
Oh, je reste ici, non?
See about the written statements.
As far as the written statements go, we were never asked to submit these for questions to be about. We were only expecting them to show up after this case had been rescheduled.
I mean, if they
Written
do
statements
anything,
aren't
we could always
the
leave
same
to go
as
along with the
questions
area.
being asked to them.
Hein? Ouais. Ok. Alors, s'il y a quelque chose... Ok, ok. Ouais, ça c'est quoi je vais vous demander. Parfait. S'il y a quelqu'un manqué dans ces trucs, je peux aller. Hein? Hmm. Et tu sais, c'est le meuf là-bas. Elle est célibataire, non? Tu peux demander pour lui, pour moi? Ouais, mais tu peux... Ok, je vais... Elle est trop belle, là. Ouais, moi, je comprends pas, mais elle est... L'accent et le voix,
Sorry, did you hear
c'est
the
mignonne.
motion? Okay, sorry, I didn't hear any response.
Bah quoi, je suis
Apologize.
français, c'est comme ça, hein.
Oh, okay.
Ouais. Oh, je m'ennuie. C'est vraiment ennuyeux, what the fuck.
Sure, but of course it's not our duty to schedule a deposition with prosecution witnesses.
No. Je crois que je vais dormir.
Hello, you gonna go to that?
Yeah. That looked really good.
Ok. Alors, l'avocat, c'est ici pour moi être libre. Ouais, c'est ça, ok. Ok, parfait. Bah, ça, c'est la chance. Wow. J'ai la chance, non?
It's alright.
I
Pourquoi
believe that
c'est
it was
long?
stated that they were under the impression that you were setting up your own depositions.
Well, again, Your Honor, overall, I don't think there's any set procedures. However, depositions are commonly conducted in both scheduled by both parties.
Ah, ok.
It actually
Bah, c'est pas un
states
problème
in
avec
the-
moi. Ah, ok. Bah, c'est quoi le problème?
Again, also with written statements, there is no need for questioning. That's not a requirement. You are welcome to file any questions that you have of witnesses of your own accord. But
Ok.
written statements
Et ils ont
are
pas là?
From them, not ask questions. It's not the same
Pourquoi?
as written statements. Like written statements are not the same as
Hmm.
written answers.
Bah alors, ça veut dire quoi? S'ils n'en arrivent pas, je peux aller
I understand the point that you're making.
sans conséquence, là?
Well, he also wanted to object to the written
Oh.
statements that were submitted by
Okay.
the officers.
Oh, sure, yeah. Of course, pursuant to that Carlos Montana ruling, they wouldn't be admissible.
Pourquoi? Quoi avec l'offre?
Great, yeah, we have two
Okay,
of those
okay.
officers here, and I can have them answer exactly what happened.
Prosecution, please proceed.
Sorry, I missed like most of the argument because I don't know. anything.
Officer, can you explain to me the incident at hand from start to finish in your best recollection?
Okay, so on the day and time as the report indicates, I responded to a police chase involving a two-door muscle car, grey in colour. I managed to catch up to the chase around about Alter Street and Integrity Way, whereby I saw Under Sheriff Stiglitz on a murder unit, as well as some LEO units from the SPDU department engaged in the pursuit already, and at which point I saw the grey and coloured two-door vehicle strike the motorcycle vehicle, trying to escape a boxing maneuver to stop the vehicle from moving. He struck it 2 times and then managed to break out of the box and then fled again from police. The chase continued on for several minutes until he went east on Occupation from Power Street, from the northbound Power Street onto Occupation eastbound, whereby he then struck a individual as a civilian on the pedestrian sidewalk as he entered the road, whereby we then made the decision to end the pursuit using lethal measures, and the subject was then shot. He was incapacitated at the wheel and ended up on Meteor Street northbound. He was then taken out of the car, placed in handcuffs, and medical was given to him by myself. Once he had received medical and his items were taken off his person, he was taken to Mission Mo, whereby we began the process to indict him for the charges.
What were the items found on his person? At least the notable ones.
I believe he was found with some money as well as a hacking tool.
Can you explain to me what a hacking tool is?
It is a device which is used to reprogram or bypass a program to make a computer work differently. So as to say,
Your
for
Honor, I'm
example-
going to be objecting at this point for expert testimony over all this officer. I don't think he's going to be a computer science expert and hasn't been submitted previously as one.
I would beg to differ. He deals with these items all day through his line of work.
Well, Your Honor, if I may, that hasn't been established through a foundational questions that he has.
It's a tenement of their job.
Which
Your Honor,
the
that hasn't
question
been
lacks
established.
foundation.
It hasn't been established on the record that that's the case.
I'll leave that to the judge to decide.
Sustained.
Ok. Elle a dit quoi? Okay.
During your pursuit of the defendant, did he ever attempt to stop?
Objection leading.
Sustained.
Can you explain to me exactly how the chase proceeded?
At high speeds through city streets with traffic in amongst them. The vehicle was driving in a reckless manner, in my opinion.
Did you have any discussions with the defendant?
Can you elaborate?
Did you speak to the defendant?
Yes, as best I could. While treating him for his wounds, he began to speak French in and out of consciousness. Using my limited French, I asked him
Oui,
if
j'ai
he
parlé
knew how
avec
to
lui.
spell,
Il a essayé avec Google Traduction.
if he knew how to speak English. He did not. And that was about the extent of it. We then took him down to Mission Road, where I then read him his Miranda rights on a piece of paper using Google Translate.
That was the only time you spoke with the defendant?
Indeed.
Understood. I believe that's all in my line of questioning for him.
Bon, ok.
All right.
Your Honor, permission to approach for cross?
Please do.
Thank you. Can you state your name again for me, officer?
Detective Ward,
Hey,
CID, SASP.
How you doing today, Officer Ward?
I'm doing well, sir. It's good to see you again.
You as well. You as well. Now, previously in your testimony, you stated that you saw a gray vehicle driving away from you. Is that right?
Indeed.
At that time, you couldn't see who was in the
Okay.
driver's seat, could you?
Not at the my apologies. Not in the beginning, no. However, he spun out several times during the chase. At which point, I was able to get close enough with my patrol unit to see into the windscreen and see him.
Okay. At that point, you didn't have any previous interactions with the defendant, did you?
Not from this.
So-
Not from.
Can
My
you answer me
apologies.
yes or no?
No.
So at that point, you wouldn't actually know who was in the driver's seat, is that right?
Leading.
And it's a cross-examination.
Leading question.
Leading is
Sustained.
permitted in cross, Your Honor.
Apologies, I've already sustained.
I'm sorry, the objection was sustained, Your Honor?
Yes, I did say the word.
Okay. Now, did you clear the store?
I was not present for that part of the scenario.
Is it typical for officers that clear buildings to state they're going to clear it over the radio?
Yes.
Were you on the radio at the time that this pursuit was happening?
Yes.
Did you hear any officer over the radio state whether or not the store was cleared?
Not at the time, however, the police pursuit was taking precedence, so that would have been on the radio.
Okay, so again, it was never stated on the radio whether or not the store was cleared, is that right?
No, I did not hear it on the radio.
Now, isn't it true that you didn't witness the defendant in this store robbery?
Again, I was not present while he was at the store, however, I learned before, after the incident, that Elios watched him leave the store. So no, I did not witness him firsthand.
Now this vehicle that you were chasing, can you describe it for the court?
It is a two-door two-door grey in color muscle car. It's a Vigero.
Gera. Okay. Do you recall the plate at all?
I would have to look at the report, but no, not from the top of my head.
Okay. If you'd like to review the evidence that was submitted on the docket, feel free, if you'd like to look over it and see whether or not you see the plate of the vehicle on there. If so, read it for the court.
One moment, please.
And if you'd like to state for the court whether or not you see anywhere submitted into evidence the plate of the vehicle.
Apologies, give me one moment. The court docket does not show the correct court case.
Of course, take your time.
I'm also going to be arguing relevance on the line of questioning.
Your Honor, I think it's going to be pretty clear once I ask these next two questions, but I can rebut if you'd like.
Yeah, please go ahead and rebut.
Of course, Your Honor. Now, overall, this is the vehicle that the defendant is alleged to have driven away from the police. Not irrelevant in any sort of capacity to ask what the plate of the vehicle was, whether there's missing evidence.
I would believe that it's would be relevant if we were claiming that he had done GTA and stolen a vehicle not of his own. That is not a charge that we are pressing. It's not like he fled in an imaginary vehicle.
Well, Your Honor, respectfully, for the purposes of what has been submitted into evidence, it's almost like this vehicle is imaginary. That's what I'm trying to get to in this line of
So
question.
you're saying that a officer's testimony regarding the vehicle which he watched the man leaving in, which the man was injured in, which he removed the person from, was just a magic carpet ride?
Your Honor,
I'll
let you-
sustain the question. Yeah, he's not in for GTA. That is correct.
Okay. You couldn't find that plate on the docket now, could you, Officer Word?
Again, she just sustained my relevance questioning.
Move along there, sir.
Okay. Detective Ward, wouldn't you agree that there is a missing piece of evidence in this case? And if you'd like, I can elaborate.
I've already assumed the fact that we're not pressing GTA. But you can question his memory if you'd like regarding the vehicle that he physically viewed.
I'm confused, Your Honor. Is there a pending objection?
Yeah, I
Ms.
objected
Kenny?
relevance.
Okay, yeah, please say the objection
Your Honor,
first before
I
the
think it's-
commentary.
I think it's highly relevant to know whether or not there is missing evidence, Your Honor.
One moment.
Yes, Your Honor.
Ils ont disputé les deux ou... J'ai l'impression qu'elle est vraiment, vraiment engueulée maintenant. Ok. Ok. Qui est nouveau? Le meuf?
All right, I'm sustaining the relevancy motion. Please open up a different line of questioning, sir.
Of course, Your Honor. Now, Detective Ward, previously in your testimony, you stated how you searched the defendant. Is that right?
I did. I searched him after he was searched beforehand by another Elio.
All right. Now, is it
Just double
true that exhibits A1 and A2 are the products of that search? That's what you found on him?
One moment.
Ok.
Like again, I can repeat the question if you forget.
Please.
Is it true that exhibits A1 and A2 are all that you found on the defendant?
It is all that I found on the defendant.
Is there someone else that searched the defendant?
Yes, another Elio on scene did beforehand, moving weapons and some contraband. I double checked just to make sure he didn't have anything left on him.
Okay. To your knowledge, was anything seized from the defendant when that other officer searched him?
I don't recall. My apologies.
Okay. Can you name the officer that also searched the defendant?
I believe it's going to be Mr. Stoner from the SPD.
Ah, il y avait deux
Do
personnes
you
qui me
see
cherchaient.
Officer Stoner in the courtroom?
I don't believe so.
Anywhere from what was submitted into evidence, is there anything to show that Officer Stoner searched the defendant?
One moment. I would say the absence of many items in his pockets would be. So, for example, weapons.
So
for
you're
example-
speculating that he had weapons on his person.
Again, I do not call what kind of weapon,
Relevance.
items.
We're not pressing weapon charges.
Your Honor, this officer just testified to another officer searching the defendant and finding weapons, and though there is no evidence to suggest that. I'm simply trying to understand the consistencies here. Inconsistencies, rather.
I think we're really edging the line on hearsay. Can we? I'm going to sustain the motion, and can you please ask some questions relevant to what he saw versus what another
Sure.
officer did?
Now, Detective Ward, as far as you are personally aware, the only items that you found on the defendant, evidence in A1 and A2,
Asked and
that's
answered.
all that he had on his person. Honor, this is a different question.
He's asked and he's answered what he found in the pockets.
Sir, can you repeat your question again, just for clarification?
Of course. Now, in your personal knowledge, Officer Ward, everything that was depicted that you've testified to in A1 and A2 is all that was on the defendant.
That it was asked and answered, sir.
I'll let you rule, Your Honor.
Oh, sustained.
Okay. Now, again, look at exhibits A1 and A2, Detective Ward. And can you specify exactly what was stolen from this store robbery in that search?
Relevance, attempted. It was an attempted robbery. We're not claiming robbery.
Sustained.
Hall, oh my god, Hall is a really good fucking competitor now. Holy shit.
All right, Detective Ward. Now, previously in your testimony, you speculated as to how the defendant may have attempted to rob this store. Is that right?
Indeed.
Okay. Now, overall, do you have experience in terms of responding to attempted store robbery calls?
Yes.
Okay. Now, overall, is it common for you to find stores where a defendant has smashed a cash register in order to rob that store?
Yes.
Speculation.
I don't understand how that's a speculatory question, Your Honor.
You're asking him to speculate in terms of if there's smashed cash registers in stores all the time.
Your Honor, I'm asking his previous experience as a law enforcement officer. I don't understand how that's speculation.
Sustain, and I suggest rephrasing the question, sir.
I believe Mr. Hunt may have some questions.
Good afternoon, Detective Ward.
Mr. Hunt, good to see you.
Likewise, how are you doing today, sir?
I'm doing well. Hope you are too, sir.
Thank you. I just want to go over just a couple of what you said during your testimony. First off, you'd agree you never witnessed any robbery, right?
No, sir.
Asked and answered.
Your Honor, if I may, Your Honor.
Okay.
What are you asking me?
To respond to the objection.
Please go ahead.
Pursuant to Rule 611A of the Federal Rules of Evidence, the question hasn't been asked, or sorry, the question was asked by the opposing party. We still have the opportunity to ask that same question. Once we ask it a multitude of times, that's when it become asked and answered.
I believe he did actually ask that question.
It's not in my notes. Doesn't sound like she exactly recalls.
I recall it. So that's up to the judge.
Honestly, I don't think it's make much difference if we overrule it. Please ask.
Sure. Okay, so again, just so we can ask you one more time. You'd agree you never witnessed any robbery occur, right?
No. Again, I arrived after the robbery had occurred and the pursuit was in full swing.
Sure. In your police report, I just want to go over it. You're welcome to pull up a copy. Would you like a copy, or do you want to recall off your memory?
That is not my police report, sir, but I can look at the report.
Oh, sorry.
Give me a
Statement.
copy.
Are you Trooper Ward?
I am Detective Ward. Also a trooper, yes.
Okay. Did you submit a statement to the court, or was that a brother of yours?
No, that was my statement, yes.
Oh, that is your statement. Okay. Okay, so I just want to go over a couple things that were stated directly inside of your statement. Just for starters, you'd agree that when you arrived on scene, the defendant, or what you're alleging, is that the defendant was ramming into a motorcycle officer's car.
No alleging, sir. I saw it happen.
Right. And when you arrived, that's what you saw, right?
Yes, sir. He rammed the motorcycle unit twice. The second time the motorcycle actually caught air, he rammed it that hard.
Right. My question is that's what you saw when you arrived, right? When you arrived, you saw the defendant ramming someone, right?
Indeed.
Right. Once you saw the defendant ramming someone, the vehicle was authorized to be code red, right?
At that point, possibly yes.
Sure.
But the call was not made at that time.
Sure. Can you describe what the court for code red means?
As previously stated, it's the decision to bring a pursuit to an end using lethal means, such as shooting the tires of the vehicle, shooting the driver, to stop the vehicle and stop it from committing any more harm to the public at large and other motorists on the road.
Sure. And that was immediately done once you arrived and you saw the defendant allegedly hitting somebody, right? With their car?
Can you elaborate on who, sir?
I'm sorry?
Can you elaborate your question, please?
Sure. So once you arrived on scene, you saw the defendant ramming a car, right? You with me?
Yes, motorcycle,
Right.
yes.
Sure. After you saw the defendant hitting a motorcycle, the vehicle was authorized to be fired upon, essentially, right?
No. That happened later when he ran over a pedestrian outside the courthouse.
How much later was it?
I would say 3 minutes later.
3 minutes. And then what was the distance between the two locations?
From Alta Street Integrity to the courthouse, I would say maybe 0.15 a kilometer.
Okay. So you'd agree that essentially you witnessed what could be deemed as an assault with a deadly weapon, per se, right?
Yes, he used his vehicle as a weapon to strike another individual.
Toujours? Okay.
Right. And that's mainly what you saw, right?
Relevance. I don't understand a line of questioning that is bringing up other charges against his defendant that are unrelated to the charges that we have pressing.
Your Honor, pursuant to Rule 401 of the federal rules, the evidence that we're asking to be admitted still relates to the merits of the case.
What federal rule is that again?
Federal's 401.
401.
Apologies. I'm going to need a 5-minute reset.
Sure.
We'll revisit this line of questioning in 5 minutes.
Sounds good.
Qu'est-ce qui se passe? Ah, ok. C'est en petite pause, là? Ah, ok.
I'm going to stand here and look my back. That's okay.
Court back in session. Honorable judges, Castillo and Mann still presiding.
All right. Thank you for that short recess. Y'all may be seated. Defense, I believe that you guys were still up. If we can roll back to, did we say the code red question?
The most recent question was.
Yes.
Sorry, did you want me to ask the question once more?
Yeah, let's
Okay.
Rewind and
Sure.
proceed from that point.
Detective Ward?
Yes, sir.
Okay, so we were talking a little bit about Code Red. So you'd agree that you testified to that Code Red essentially means it's giving you the lethal authority to use lethal force on a person or vehicle, right?
Relevance as to the charges being pressed.
Defense?
Again, Your Honor, it's still relevant to the case and it's still a material fact. As the officer did explicitly mention Code Red, not only in his testimony, but also inside of his report.
I'll allow it this time. We'll see where it goes.
Right. Truthfully, sir, my question wasn't that important, so I'll move on. So if you could just direct your attention to your report, I'm just going to ask you a couple questions about that, all right?
Okay.
And let me know when you have that. And Detective Ward, just to ensure, you did write this report, right?
I did.
Okay. All right, if you can direct your attention to paragraph 2, it is sentence 3, while responding to 444. Do you see that part?
I do.
Can you read out to the court that sentence?
While responding to 444, I heard over the radio he was being rammed by the suspect vehicle.
Okay, you can just continue on.
Okay. 444 at the time was on a motorcycle unit with little protection, and the decision was made to use lethal force to stop the vehicle as so to prevent further harm to the public, other motorists, and 444.
Okay, so you would agree, by this point of your report, you're not at the pursuit, right?
No.
You're solely relying on what's being said over the radio, right?
Indeed.
Okay, so I'd like to direct your attention, to paragraph 3. You'd agree it states, I cut up to the chase on Alta Street where I witnessed the suspect vehicle ramming 444 on his mortar unit, right?
Yes.
And at one point, sending it briefly airborne.
Indeed.
Right. It continues to say, alongside me at the time was 512, Lincoln Stoner, at the time Cadet C. Foster, call sign 907, of whom with 444 opened fired on the ramming suspect, right?
Yes.
Right. So from your report, you'd agree that, basing off the report, it states that you caught up to the chase, you witnessed the suspect vehicle ramming the mortar unit, at which point your officer and cadet fired upon the vehicle, right?
Yes.
Right.
Again,
And at this
relevance
point-
as to
Is
the
there a question?
charges being pressed.
Defense?
Sure. As stated earlier, Your Honor, pursuant to the federal rules, it's still relevant to the case. It doesn't necessarily have to be relevant to the charges that are being presented. Of course, in our defense, the question I'm about to get to is about to lead as to why I was asking that question.
Okay, let's get to that question, please.
Sure.
And overruled.
Right. So you'd agree that at this point you're firing at the suspect, right?
The other units were yes, I was not.
Right. And at that point, was he subdued, or at that point did he start driving after that point?
He was driving at that point, still fleeing police.
Right. So from your perspective, you'd agree that you were shooting at the person inside the vehicle while they were running, right?
Yes.
Right. So you saw, I'm going to rephrase. You didn't see the pursuit leading up to. All you saw was a defendant fleeing while he's being shot, right?
No, sir. I saw him ram 444, Hugo Stiglitz.
Right, I understand. And at that point, the defendant was getting shot at, right?
Yes.
And that's when you saw him actually evade, right? This is actually you seeing him evade.
Yes.
Right. So you'd agree that the only time you actually saw the defendant evade is when you were shooting at him, right?
From my perspective, yes.
Right. And you'd agree it's pretty reasonable for someone to drive away while they're being shot at, right? They're not just going to sit there and get killed, right?
There is some logic to that, yes.
Compound
Right.
question.
Repeat your question again. Clarity.
I don't recall the exact question. I'm not.
He asked 2 questions in a row without allowing the witness to answer either.
Okay, sustained. And from my understanding, there have been many compound questions, so one at a time, and allow the witness to answer them one at a time, please.
Sure. I don't recall where I was, but I'll go back to my point. So just to go back where we were just talking about, you only saw the vehicle drive away while they were being shot at, right?
Yes.
Right. and then you testified to the fact that you'd agree that it's quite reasonable for someone to drive away while they're being shot, right?
Opinion. He's asking for his opinion.
It's not a valid objection according to the federal rules, Your Honor.
Opinion is an objection.
Not a valid one according to the federal rules, which is recognized in the state.
Just a moment.
Then I'll also press for speculation.
Oops, sorry.
Googling everything. Learning so much.
Kind of look like a Google.
What?
With your one class.
Yeah, man, it's a Google monocle. I'm Googling with my Google monocle. It's like an Apple Watch, but a monocle.
Google. Called Moogle. Gonicle. Gonicle.
Google
Yeah, but it's not
monocle, like an
recognized
Apple
as a
Watch.
problem.
It's like a gonicle.
Well, sure.
Or a Moogle.
If we could do that.
I mean, if you want, you can cite it. I don't mind.
On a Google.
All right.
Google.
What's going on, man?
Your Honor. Oh.
Okay, as it was, what is it? I just forgot the word. Sorry, since it was an objection to the opinion, and it was purposely stated by the defense that this individual is not an expert witness, then the motion to object to the opinion is sustained.
Your Honor, if I may briefly, we're not asking him to give his opinion as an expert. He's still a lay witness, and then according to, I believe Mr. Hall wanted to cite case law.
Yeah, so Your Honor, as
You're
far
also
as
making him make an assumption regarding his decision in an
Your Honor,
unrelated position. You're asking
I
him
may.
whether fleeing suspects should flee and continue to flee from being shot at. It's asking for an opinion, and it's assuming
Your
it's
Honor,
asking for something unrelated
Mr.
to
Hall
what
is
his expertise would be.
attempting to cite case law. With regard
as
to
far as this case, Your Honor, and the specific question, this witness is a lay person to this question. This is something they witnessed, and therefore, under Federal Rules of Evidence 701, a lay person can give. I apologize. This is more. I'm sorry. U.S. versus Williams is pretty clear case law on this. Overall, a lay person can give opinions, inferences, and of course, only when that witness is giving an opinion on an event that they were actually present to.
in
This
this
is
case,
exactly what this
Trooper
question
Ward
is.
was.
But they could petition to have it be accepted for future cases.
Well, Your Honor, we still would submit the basis of that case law. Overall, a lay witness should be able to testify to their opinion
To
on a specific
speculation?
event if they are present for that event. Of course, to help the jury and, or not jury in this case, but the
So I would
judge
argue that
understand the facts that are actually being presented.
they're asking for his opinion regarding how he feels about the defendant running, a speculation as to, do you believe that somebody should run when being shot at? Again, speculation. The foundation, there's no reason to be discussing why a defendant should run from police.
So my question wasn't at
Gentlemen.
all involving the defendant.
Sir, the I've already sustained the objection.
Sure. Okay, so let's wrap this up because we're getting kind of long-winded here, and I apologize because we only have one bite at the apple. So the only time you saw the defendant run was when you guys were shooting at the defendant, right?
Indeed.
Right. You never saw the witness evade beforehand.
No.
You never saw the defendant rob a store or attempt to rob a store, right?
No.
Right. I have no further questions. Thank you, Your Honor.
Prosecution, would you like to redirect?
Absolutely. Thank you so much. Okay, so did you join an ongoing pursuit?
Yes.
What was the call made over the radio that you witnessed being said?
Objection, Your Honor. I'm going to, of course, object to hearsay. There are no witnesses from the radio, from my understanding, that are going to testify to what they said.
I would say that he heard it with his own ears over the radio.
I'll allow it. As defense did ask if he heard if there was any other calls over the radio.
Can you repeat the question again, please? My apologies.
Of course. What did you hear over the radio regarding the pursuit?
That there was a pursuit going on. At one point, again, the vehicle in question that the defendant was driving was ramming a motorcycle unit, at which point the call was made to open fire on the vehicle. While in the pursuit also, I heard over the radio that also he had been prior to this in another pursuit, or was in an ongoing pursuit. However, visual contact on the vehicle was lost again, but soon after required.
Did you hear a call out over the radio regarding what the description of the vehicle leaving the robbery was?
Yes, a two-door grey muscle car.
This was what you pursued and joined in pursuit later in the pursuit. I said pursuit 3 times, yep.
Objection, speculation.
It's the facts. He is connecting that he heard this car and is matching it to the car he viewed.
I do have a rebuttal.
Your rebuttal, sir?
Yes, so, Your Honor, this witness was not present at the robbery. He can't testify to what he didn't see. Overall, he can, of course, testify to pursuing a black Figaro. However, he wasn't at the robbery to discern whether or not this is the same black Figaro, and that's a basis of the objection for speculation.
I would say overruled, as he can testify what he heard. Police officers do relay this information to communicate among their forces. That way they're I'm sorry, I'm not sure that was relayed, sorry. This way that they're able to follow the correct vehicle.
Okay, I can ask again. Was that the same vehicle that you joined in the pursuit and followed?
Indeed.
Can you describe the vehicle
how is that not speculation?
Can you describe the vehicle when you joined the pursuit and the damage that was in the vehicle or on the vehicle?
At the point I joined the pursuit, it was a grey two-door muscle car, a Vaquero, as I've already stated. At the time, it had no damage. However, upon ramming said motorcycle, I believe it had a scratch to its front fender. That's it, until we began opening fire.
Of course. And throughout your time on radio, were they continuing the pursuit up until you joined?
Yes.
Objection, speculation.
I would say that he's listening to the radio of them continuing to make call-outs while in pursuit of this vehicle.
Again, Your Honor, he can testify to what he heard over the radio, but not actually what these officers are doing. He's not a witness to that.
Prosecution, what was the question again? I'm so sorry.
I was asking if he heard a consistent pursuit taking place from the time of the robbery until he joined.
I would say overruled.
Okay, I believe that's the end of my questioning frame.
No, I apologize. I meant to say sustain. My apologies. Since you're asking what he heard during the entire emissions of the radio.
Okay, so he can answer.
Yes, yes, ma'am.
Wait, Your Honor, if the objection was sustained, then he can answer.
Oh, I meant to say that she could allow the question. I said the wrong word. My apologies.
Okay.
I'm a little confused.
So am I. I will allow the question. Let me
Oh,
just
okay,
clarify it better,
Sure.
as I've forgotten the word I was supposed to say. My apologies.
Sure,
Okay.
my apologies, Your
Okay.
Honor.
Would you like me to repeat, or are you okay?
Please.
Okay, so from the time that there was a call of the pursuit beginning to you joining, was there consistent radio discussion about this pursuit that you heard?
Yes.
And that's the end of my questioning. Thank you.
All right, sir, you may be excused. Prosecution, do you have any further witnesses?
If the Mr. Stoner is in here, as well as if Stiglet has arrived.
Neither.
Neither.
C'est bon pour moi. Okay.
Neither have arrived. No.
Okay, okay,
Okay,
parfait.
then let me have a quick chat.
Your Honor, since the state's about to rest our case, we'd like to revisit our earlier submitted motion now that the court's heard that testimony.
We'll get to that shortly.
Sure.
Yeah, due to we are resting our witness section because there's no other officers here.
Do you have any additional evidence to show to the court?
We do not.
All right. Defense. You have the will.
Sure. Is this with regard to the motion?
Yes, if you'd like to bring it up again.
Sure. Sorry, I wanted to get a prosecutor a copy of the case law because I recognize. Raiden, are you able to give her a copy of the Carlos Montana case law?
Okay,
Sorry.
let me step out of the courtroom real quick.
Well, Your Honor,
What's
as we stated earlier to the court, again, we'd request that the court dismiss this case because on its face, it lacks the constitutional sufficiency needed to allow the defendant to be charged with any crimes. As you've heard from the only witness that has testified today, he did not directly witness the robbery, and I'd contest to the court that he did not witness the actual evasion. Everything that he testified to was what he heard over the radio, not anything that he had physically seen. Of course, in the case of the state of San Andreas v. Carlos Montana, the defense constitutionally has the right to cross-examine witnesses, and if that's not available, then we have the right to be present during a deposition. In this case, the state conducted a deposition with, I don't remember how many witnesses, but regardless, they conducted a deposition. We were never invited to the deposition, which is explicitly required under that case law. Again, in this case, there's not enough evidence to allow it to proceed based on the fact that we aren't able to cross-examine any of the key witnesses inside of this case. The only witness we were allowed to cross-examine was the witness who didn't witness anything. He solely heard everything over the radio.
In the 9 days that you had for evidence, did you arrange your own deposition?
Your Honor, again, so the defense, we specifically stated on the court docket on the 10th, I believe it was, that we were not invited to this deposition. Again, as Mr. Hunt previously stated, under State v. Montana, the defense is legally required to be there at all depositions before they can take place. We were never sent an invitation to this deposition. We were never notified. We were never given any, I guess, notice as to how to get involved in this officer. If there truly was no way for us to do it on the same day. And therefore, it wasn't a proper deposition. It was brought up by defense previously, and of course, that wasn't ruled on.
Doesn't answer my question, though. Did you arrange for your own deposition? As prosecution, doesn't necessarily need to be present there.
Your Honor, the prosecution, sorry, and I should state, I accidentally cited the wrong case law. It's Philip Walker. Sorry, that was the other case I was on. I apologize.
Yeah, I was just reading through it, and I was going to say, yeah, we'll go with that case.
Mr. Raiden, I can't hear you from there, sir.
I was just about to tell the counsellor that the case law he has stated has nothing to do with this case whatsoever.
Yeah, I apologize. It's Philip Walker. And I can respond when you'd like.
Yes, I would like an answer to, did you attempt to arrange for a deposition with anyone who stated that they could not arrive to the court? Did you, defense, arrange for a deposition as you had plenty of time to do so?
We did not, Your Honor. But again, I disagree with you that the defense has to arrange depositions. It's the prosecution's witness. They have to get with us, and they have to get with the deposition. Of course, if it was one of our witnesses who had to testify, we'd have to get with them, and we'd have to schedule a deposition with them. But we can't contact a witness that's actually on a case. We'd be tampering with the witness.
I would also like to argue that there were written statements, and that is a very accepted federal evidentiary process in which written statements can be submitted to the court. With or without the deposition, they did not object to any of those written statements either.
We did, Your Honor.
We did, and they also weren't admitted as evidence. Well,
They were being held. They were being held.
Right. And also, I recognize Ms. Kennedy's new to the courts, but of course, as this court has established, those written statements aren't admissible, again, unless we were able to cross-examine. And again, that comes back to the deposition question.
I would also rebut that the court can actually overrule any of their precedent if they find that it would be expedient for the court to actually be accepting written statements into evidence which is federally accepted.
No, Your Honor, she's absolutely incorrect. The
You
Supreme
can overrule
Court,
precedent, absolutely.
The state Supreme Court has ruled you can't go over the state Supreme Court decision, or again, the state Supreme Court will come back and strike down the verdict, and we'll just be back right where we are. That's
Precedent
like saying,
can be set and changed.
That's like saying a
all
district
of the
court
time.
can disagree with the United States Supreme Court. No, you have to follow the precedent.
There's actually
that's been set.
separation of state and federal, so yeah, they technically could.
No.
Okay, we're going to take a 5-minute recess while we make a decision upon this motion. Thank you.
Laisse-moi parler avec elle. Non, man, non.
Hey Teddy, can you say some words for me?
Et ça, c'est en caméra?
That sound like-
Salut! Salut!
Okay.
Just say D-bar.
Dehors.
I think he's asking if you're on. He's asking if you're on Tinder.
Even I understood that.
Want a request for deportation?
He also said something about he would swipe right,
All right,
or
let's
something like that.
quickly before we have to leave.
I'd swipe right on
Oh,
Teddy.
everybody's back. Everybody's back.
All right, sorry, we can get back to that quickly.
That's English, you ignorance.
Elle est tellement sérieuse, mais on peut prendre l'autre femme aussi, à 8 personnes, pourquoi pas?
Oh, okay.
Ouais.
All rise. District Court will now be back in session.
All right, you may be seated. In regards to the statements submitted on the docket, as I did request either a signed affidavit or a deposition, these statements will not be entered into evidence. And then in regards to the deposition, per Rule 30, depositions by oral examination, there is supposed to be a written notification to all parties. Defense, were you notified of the deposition?
We were not, Your Honor.
Okay, so the deposition will not be entered into evidence. Let's not let this happen again.
Your Honor, can I ask a question on your decision?
You may if it's real quick.
Yeah, when in the description of discovery period on the docket, you stated all first-hand witnesses that cannot attend this trial must provide a written statement describing the incident.
Did I say a written affidavit?
Nope.
Just for clarity, what was the ruling on the motion to dismiss?
Denied.
Would also argue that that could be seen as an affidavit. It was written by them. If you guys have a formal setting of affidavit that you would like instead,
we do.
Statement. Okay.
The defense is ready to proceed with closing statements.
I would like to reiterate that you actually said written statements, so I would motion to
I mean,
have them put back
Let me just review that real quick.
Well, Your Honor, the court may.
I just need a moment to review that, please, sir. Just give me a moment, please. Okay, October 8th, I did say I would recommend working with your witness to arrange a deposition or have them submit a signed affidavit. The DA's office must be prepared for situations such as these. Later, I did go on to clarify that a signed affidavit would be most preferred.
But also argue that I believe there was weather and flight delays that meant that the deposition was not with all parties. I don't know if that was due to us or the fact that there was another attorney that was assigned to this case as the public defender. So
Your Honor, the ruling has already been made. They can appeal it to the appeals court if they like, but we'd like to proceed today, if at all possible.
I would recommend appealing if you feel my ruling on that statement motion is untoward.
Thank you, Your Honor.
Just a minute, I need to I need to eat something real quick.
D'accord.
Where are we now?
Je comprends.
It's up to you. What do you want? I don't mind.
Okay, defense, do you have any witnesses today?
No, Your Honor.
Yeah, it's not.
Alright, I believe we're going on closing statements. Let me double check my list here. I'm so sorry.
D'accord.
Prosecution, I did ask if you had any additional evidence. Is that correct?
If you can give me a second, Your Honor.
Yes, sir. Just want to make sure I didn't forget something.
Is Mac Foster in there?
You could tell him that a couple of the pieces of evidence.
No, he's not.
Oh, it's a different Foster, don't worry.
We're all good there, sir?
Seeing you're not allowing 95% of the evidence, yes, ma'am.
All right. Okay, we'll now proceed. I'm sorry, do you guys need a recess before we go to closing?
I probably just need 2 minutes.
Defense?
Oh, we're ready to proceed, Your Honor.
We'll
sorry. We
allow
can go in the 2 minutes recess. Sorry.
2 minutes? Okay,
Yeah, however long the prosecutor needs.
Okay, 2-minute recess. Smoke him if you got him.
Pendant
Okay,
que
I'm kidding.
repose. Putain,
Don't
pourquoi?
smoke.
Ok, parfait. Mais est-ce que vous avez un peu de bouffe parce que moi j'ai faim? Wow, fromage, quel fromage? Fromage des États-Unis ou? Ah bon, prix, moi j'aime pas trop, bah ok. Hein. Ouais, c'est bon, ça marche. Hein. Merci. Ah, t'as le croque, monsieur? Ah, bah ça c'est très bien. Ok.
What is going on?
Parfait. Oh, moi j'adore le croque, monsieur. En fait, le truc que j'aime pas trop, c'est le fromage des États-Unis. Hein. C'est trop plastique. Ouais, c'est dégueu. Bah, le croque, monsieur. 100%. Ouais, le madame, c'est un peu nul.
All right, Luca, we're going for escargot after this.
Ça, non. C'est trop. Moi, je mange trop. Après du ski, du fondu, oui. En fait, moi aussi, j'adore le raclette.
I can't have
Bah oui, ben ça c'est c'est presque la raclette. Hein.
So, do you want to go bald with me?
Hmm. En fait, cette année, je pense que je vais aller au Suisse, en fait, faire le ski. Et après, je vais manger un grand fondu. Là.
No, no, no. Oh God.
Ah, ok. Ouais, ouais. Tous les gens disent Valais, c'est mieux aussi. Hein. Ouais, ouais.
Hey there, how's it going?
Oh, je suis fatigué. Non. Non, j'ai pas vu.
Nope, I will be pursuing the charges in a closing statement.
Oh, je pense. On va continuer.
You heard the lady?
Non, non en fait, j'ai allé en Suisse une fois, une seule fois. J'étais pas là. Bah,
No,
j'habite
I
ici
gotta
maintenant.
say, she's not gonna get it, but she kind of reminds me of Blackstone. Just like a smarter version of Blackstone. With all respect to Blackstone.
But do you want to go back over there?
All
and let's work,
rise. District Court of San Andreas back in session. Honorable Judges Mann, Honorable Judges Castillo, presiding.
Thank you. All right. Prosecution opening. I'm sorry, closing statements, if you would.
Of course. Short and sweet is what I'll dub this one. As shown through the testimony given today, there was a clear connection and line of communication over the radio in which officers responded to a scene of a robbery, called out a vehicle, and remained in pursuit of that vehicle. It was clearly identified, it was clearly pursued, and the witness at hand joined the ongoing pursuit of the defendant. There was clear evidence that the defendant was evading from the scene of the crime, as well as ramming officers. The witness confirmed that the defendant continued to evade, which the witness, again, was part of, joined in the pursuit of. The defendant was subdued in their evasion attempts. Items used in the commission of a robbery, which the entire pursuit originated from, were in the pockets of the defendant. They are used in the commission of a robbery. There is no coincidence that that evidence was in that man's pocket during the pursuit from a robbery. So I will continue to press that this man is guilty of attempted robbery as well as evasion. Thank you.
Defense?
Of course, permission to approach, Your Honor?
The will is yours.
Thank you. Ladies and gentlemen of the court.
Okay.
This case overall is a fairly simple one. What we've heard today evidence that the defendant is guilty. Evidence that he's anyway criminally culpable for the charges of attempted or unarmed robbery, and the charge of felony evading law enforcement in a vehicle. Now, solely what this court heard is a testimony of Officer Ward. Now, the testimony of Officer Ward could not, in his testimony, he did not testify to the robbery. He did not see the defendant actually attempt to rob this store. The only thing that he heard, the only thing that was submitted in his testimony was hearsay. Hearsay from the officers over the radio, hearsay from officers that may have talked to him after the fact. Overall, in this case, we do not have evidence that the defendant attempted to or completed a store robbery. We just do not. The witness that was on the stand simply testified to the fact that he heard a store robbery occurring and that he saw a Vigoro that he ended up dealing with later on. Overall, that is not enough evidence to convict an individual in the United States of America. There needs to be proof beyond a reasonable doubt that the defendant attempted to rob this store. It was never testified to what this store was, where it was, who owns it, what was attempted to have been stolen, how did the defendant do it. We didn't hear any of that. because the witnesses that testified did not see that. That is not evidence the defendant is guilty. Now, secondly, we heard this witness, Detective Ward, testify to a striking of another officer's vehicle, a motorcycle. We heard about that extensively. Overall, the defendant is not being charged with any form of assault with a deadly weapon or assault. He's not being charged for any attempted or, any sort of striking of that motorcycle. Now, the only thing that this witness stated in his testimony that he saw was the striking of the motorcycle and then the shooting at the defendant. This witness did not testify to how he saw the defendant actually being evaded by the other officers. Specifically stated that he only heard it on the radio, which is hearsay. Those other officers did not testify today. Now, because the only thing with this pursuit that we've heard is hearsay, this court may say, hey, what about the defendant? What about when they, fled from Officer Ward? That's what he stated in his testimony. Officer Ward stated, the defendant, after this crash, he took off. Well, defense would assert and ask this court to consider what is reasonable for a defendant to do in that situation. We heard from the officer testimony of Officer Ward, that as soon as that crash took place, a code red was activated. That means that all officers on scene started to shoot at the defendant. I don't know about all of you, ladies and gentlemen, but I believe that when you are being shot at, it is reasonable, no matter what the situation is, to try and get out of that situation. Try and not die. That is what Officer Ward saw. He saw this crash, and he saw the defendant take off from bullets almost hitting him. Officer Ward did not see a pursuit. He only heard it on the radio. Again, that is hearsay. The defendant is not culpable in terms of a felony evading law enforcement in a vehicle charge. He was under duress. He was being shot at. And anything that took place previous was not witnessed by Officer Ward. Therefore, that does not amount beyond a reasonable doubt that the defendant is guilty of that evading charge. Everything that took place after the crash that the officer did witness was reasonable for the defendant to do. Therefore, Your Honor, defense would ask that you adjudicate the defendant not guilty on all charges.
All right, we will go and deliberate. We'll be back shortly. Thank you.
Si t'es pas intéressé, c'est pas un problème. Moi, je veux toujours dire que vous êtes vraiment très belle. Hein?
District Court of San
Back in session.
Back in session. Your Honorable Judge Castillo presiding.
All right, thank you for your patience. Let's see here.
Fine.
In the charge of attempted or unarmed robbery, we're finding the defendant not guilty today. In the charge of felony evading law enforcement, we are finding the defendant guilty of these charges.
Thank you.
Just to give some explanation of these charges, as the statements were not entered into evidence, the line of questioning by defense using Mr. Ward's statement against him will be stricken from the record, as they did actually ask for those statements not to be used as evidence. So there is that. But we do find that there was sufficient eyewitness evidence from Detective Ward to find the defendant guilty of evading law enforcement as he engaged in the pursuit of said individual. The ruling was, and court is adjourned. Have a good day.
It's not worth appealing.
We missed the whole
Oh,
case.
crud. Did you already? I feel like I must have missed something. I apologize.
Judge York, before your next bench trial.
Seulement le que je bah, oh, c'est pas exactement vrai. Bah, ok.
What was the decision in terms
Bah,
of
c'est la vérité, hein, parce que j'ai pas voulu.
The sentencing part Okay. Can we? Let's forget. I just said that the court was adjourned. Apologize. Oh, let's see here.
Well, the court was adjourned,
Prosecution.
so.
What is your
Let's-
recommendation for?
I'm leaving that.
We'd like the death penalty, Your Honor.
Denied.
I believe it is already time served.
Yes.
Your Honor, I think the defendant would like to make a statement to the court.
Please do.
Good lord.
Oh boy.
Qu'est-ce qui se passe?
If you like to approach, sir.
Oh, d'accord, ok, ok.
He has to give a statement about why he should be not sent to prison. No, but
Je vais aller en prison?
and with regard to the fine, why he shouldn't be, I guess you could not worry about the jail time, the fine.
Ok. Je dois aller où? Je dois aller où? Frigga. Non, non, non. Bon, ok, je peux faire ça. Là, là-bas? Ok, ok. Bonjour,
Bonjour, sir.
Ok. À tout le monde, je veux pas aller en prison et je veux pas payer le demande pour l'argent, ok? Seulement pour la raison. Ok.
Hello, everybody. I would like to explain why I do not.
Shout.
Louder. Hello, everybody. I would like to explain why I do not need to pay the fine.
D'accord. Seulement pour la raison parce que il y a beaucoup de femmes qui est vraiment très belles et si je paye le fine, ok, le fine c'est le mot pour vous, je veux pas avoir l'argent pour prendre les femmes sur le restaurant ou quelque chose comme ça. Je veux payer pour le dîner.
Vraiment, Luca?
Bah oui.
Okay. I should not need to pay the fine because there are many beautiful women here and I would like to take you all to dinner instead.
Denied.
Also denied.
That's awful.
Nope.
I'll go to dinner with you, Luca.
Qu'est-ce qui se passe?
Désolé, Luca. No.
Is it steak?
Alors,
Ruby, c'est en commun, c'est la viande?
hein?
I don't go on dates with criminals, sorry.
I'm not picky.
Ruby demande, qu'est-ce que c'est pour manger? C'est avec la viande?
Bah oui, le bœuf, le bœuf et les frites, c'est ouais, ouais. Ok.
Yeah, he can do steak and chips for you, Ruby, if you like.
Oh, thanks.
Congrats, Ruby.
Luca, what the hell, man? I want to come.
I believe that's all, Your Honor.
Thank you.
C'est fini. Ok. Merci
Alright.
beaucoup, madame.
Oui. All right. So
She
we'll go
just
with
say
time
oui.
served and a $3,000 fine today.
Yes, sir.
And I hope this fine doesn't prevent you from taking the nice ladies of Los Santos out on a date to Pearls.
Elle dit quoi?
Thank you, Your Honor.
Yes, sir.
Your Honor.
3000!
I think we're dismissed for real.
3000 balles!
Court dismissed.
See.
Unless I forgot something again.
Okay, attorney,
Ben,
state
si je
attorneys.
paye 3000 balles, j'ai pas d'argent pour payer pour les
Yes,
femmes.
ma'am.
Raiden
Alors,
to put
c'est
down.
Candice?